A pleasant day to each and everyone, especially to you, ma'am. I am Marimar Oclida, and I'm going to discuss now the chapter 7 of this subject, Legal Aspects in Tourism and Hospitality. It is entitled Laws Regulating Transportation Establishments. But before we go into the topic, we have here our learning objectives. First, is to identify the laws affecting the transportation sector. Second is to identify the rights of passengers of commercial transportation. And last is to explain the relevance of these laws to the promotion of tourism in the country. So we have here our topic outline. First is the law on common carrier. Second is liabilities of common carrier for the acts of employees and strangers. Third is enforcement of liability of common carriers. Nature of airlines, bus, and shipping tickets. Next is seatbelt law. Then we have the law on transportation of animals, law on importation of vehicles, and lastly is the traffic law. So, here is the introduction of this chapter. The Philippines has become one of the promising tourist destinations due to the extraordinary hospitality of the Filipinos and the diversity of tourist attractions in the country. However, one challenging aspect of promoting inbound tourism in the Philippines is the security and safety issue. On one hand, some of the best transportation and travel professionals are Filipinos, like for example in seafarers, pilots, drivers, flight attendants, cruise cabin crew, aircraft mechanics, and more. On the other hand, some of the worst recorded transportation disasters and accidents are in the Philippines. The transportation sector is thereof greatly affected by this concern. This chapter will deal with the different laws affecting the transportation sector as they are integral in the study of tourism. So first law is the Article 1732. It is stated that common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods or both by land, water, or air for compensation offering their services to the public. So, a common carrier is defined as one holding itself out to the public as engaged in the transportation of freight or passenger for hire. It is one who is in the business of transporting goods or persons for hire as a public utility. A private carrier, in contrast, is not in the business of transporting public employment but hires out to deliver goods in particular cases. Both the Civil Code and Code of Commerce give clear-cut divisions between contracts of carriage of cargo and contracts of carriage of passengers because the rights and defenses in each kind of contracts are different from the other. So here are the responsibilities of common carriers. Stated in the Article 1733, common carriers from the nature of their business and for reasons of public policy are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them according to all the circumstances of each case. In Article 1755, a common carrier is bound to carry the passenger safely as far as human care and foresight can provide, using the utmost diligence of very cautious persons with due regard for all their circumstances. While Article 1756 stated that in the case of death or of injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary diligence as prescribed in Articles 1733 and 1755. While Article 1757 stated that the responsibility of a common carrier for the safety of passengers as required in Article 1733 and 1755 cannot be dispensed with or lessened by stipulation by the posting of notices, and by statements on tickets or otherwise. So, as soon as the passenger puts his foot on the platform, the obligation of extraordinary diligence of the common carrier begins. The relation of carrier and passenger does not cease at the moment the passenger alights from the carrier's vehicle at a place selected by the carrier at the point of destination, but continues until the passenger has had a reasonable time or a reasonable opportunity to leave the carrier's premises. So, a certificate of public convenience is not a requirement in order for a common carrier to incur liability. Such liability arises from the moment a person or firm acts as a common carrier without regard to whether or not such a carrier has been granted or has not been granted a certificate of public convenience or has complied with the requirements of the applicable implementing regulations. Moving forward, we have the liabilities of common carriers for the acts of employees and strangers. So in Article 1759, common carriers are liable for the death or injuries to passengers through the negligence or willful acts of the former's employees, although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. This liability of the common carriers does not cease upon proof that they exercise the diligence of a good father of a family in the selection and supervision of their employees. So for a business company, for a bus company, due diligence in selection of employees is not satisfied by finding that the applicant possessed a professional driver's license. The employer should also examine the applicant for his qualifications, experience, and record of service. Due diligence in supervision, on the other hand, requires the formulation of rules and regulations for the guidance of employees and issuance of proper instructions as well as actual implementation and monitoring of consistent compliance with the rules. For a shipping company, the vessel must be considered seaworthy, adequately equipped for a voyage and manned with a sufficient number of competent officers and crew. Next, we have the law on natures of airline, bus, and shipping tickets. The best evidence of a contract of carriage is the passage ticket. Under our jurisprudence, an airline, bus, or shipping ticket is a contract of adhesion considering that all the provisions thereof are prepared and drafted only by the carrier. The only participation left of the other party is to affect his signature thereto. In such situation, the Supreme Court ruled that the terms thereof must be interpreted against the party who drafted the same, in this case, the carrier. Such contracts of adhesions are not entirely prohibited and are in fact binding regardless of whether or not the passenger or shipper had read the provisions thereof. Then we have also the seatbelt law. The seatbelt law was enacted to secure and safeguard its citizenry, particularly the passengers and drivers of private and public motor vehicles, from the ruinous and extremely injurious effects of vehicular accidents. In order to secure the safety of the passengers and drivers at all times, the mandatory enforcement of the use of seatbelt devices by the drivers and front seat passengers of private and public motor vehicles shall be enforced. So this law highlights that the driver and front seat passenger of a public vehicle are required to wear or use their seatbelt devices while inside a vehicle of running engine on any road or thoroughfare. In addition, the driver The driver of public motor vehicles shall be required to immediately inform and require the front seat passengers upon boarding a vehicle of running engine to wear the prescribed seatbelts. Any passenger who refuses to wear seatbelts shall not be allowed to continue his or her trip. Second, infants and or children ages 6 years old and below shall be prohibited to sit in the front seat or any running motor vehicles. Next, it shall be unlawful for any person to import or cause the importation of any vehicle without appropriate and operational seatbelt devices. And last, for new vehicles, compliance is required for registration. Failure to comply shall disallow the registration or renewal of the registration of vehicle at the LTO. So, moving forward, we have the law on transportation of animals. By virtue of Republic Act 8485, also known as the Animal Welfare Act of 1998, it shall be the duty of any operator of any land, air, or water public utility transporting pets, wildlife, and all other animals to provide in all cases adequate, clean, and sanitary facilities for the safe conveyance and delivery thereof to their consignee at the place of confinement. The animals shall be provided sufficient food and water while in transit for more than 12 hours or whenever necessary. No public utility shall transport any such animal without a written permit from the Director of the Bureau of Animal Industry or his or her authorized representative. Any form of cruelty shall be penalized even if the transported has obtained a permit from the Bureau of Animal Industry. Cruelty in transporting includes overcrowding, placing animals in the trunks or under the food trunks of the vehicles. So, in order to assure safety of passengers and crew members of aircrafts or vessels, it is necessary to obtain a shipping permit from the Bureau of Quarantine before an animal may be allowed to be transported on board. A valid health and rabies certificate must be obtained from the agency concerned at the port of origin shortly before shipment. So the certificate will be required by the veterinary quarantine officer upon arrival at the port of disembarkation. Any pet without such a certificate will be detained by the Bureau of Animal Industry until cleared. Next is the public service laws. The public service includes every person who may own, operate, manage, or control in the Philippines for hire or compensation with general or limited clientele, whether permanent, occasional, or accidental, and then for general business purposes, any common carrier, railroad or street railway, traction railway motor vehicle, steamboat or steamship line, ferries, and watercraft shipyard, and more. Unless otherwise exempt, no public service shall operate without having been issued a certificate of public convenience or a certificate of public convenience and necessity. So public utilities are privately owned and operated businesses whose service is essential to the general public. They are enterprises which specially cater to the needs of the public and conduce to comfort and convenience. And last is the traffic laws. According to Republic Act number 4136, which is enacted on June 20, 1964, is a compilation of laws relative to traffic rules and regulations. Traffic laws are regulations that govern the movement of vehicles and pedestrians on roads to ensure safety and efficient transportation. They cover various aspects, including speed limits, traffic signals, lane usage, and right of way rules. Violations can result in fines, penalties, or legal consequences. It's crucial for drivers and pedestrians to be familiar with and adhere to these laws to promote a smooth and secure flow of traffic. So, conclusion, the laws regulating transportation establishments play a crucial role in ensuring safety, efficiency, and environmental sustainability. These regulations cover areas such as vehicle standards, driver qualifications, and traffic management. Effective enforcement and periodic updates are essential to adapt to evolving technologies and address emerging challenges in the transportation sector. Overall, a well-crafted legal framework is vital for fostering a secure and orderly transportation system. So that's all for my chapter 7. I hope you have learned something. Have a nice day ahead and thank you for listening.